We need to do that for water as well, and there are some people in the US who call it wet growth. I'm not clear that I love that term, but as we marry land use planning fundamentally with good water governance and water management principles, they have to be pulled together, and we can do that in a variety of ways, either through watershed plans directed from a provincial level that can have an impact on water entitlements, or through regional growth strategies and more land use type tools. There are a variety of different ways that we can do that. It is around compensation for water entitlements. We have in many areas too much water allocated in certain surface water sources. It's not clear that there will be, and it's also very clear that we need water for fish, and a conversation about priority of water uses in a region. It's not clear that there will be any money for compensating water license allocations in terms of clawing back those allocations, and there certainly is no mechanism under the Water Act for doing that. So the way in which the law looks at that is you have a water entitlement, it's treated as a quasi-property right, and you're able to exercise that. You have to be compensated in order to not have that anymore. So if we think of our piece of land, clearly the province can't take it or take it back without giving us money for that. But what the government certainly does, and local governments do this very well and clearly, is they say, in the public interest, we want you to only use your land for certain things. So as a single family homeowner, I cannot put up a lead smelter on my residential property. And that is regulation. I don't complain about that because we all agree to zoning as a way of maintaining property values and ensuring that overall the public interest is upheld in our communities. And this is well accepted in law in Canada. In fact, there are statements from the Supreme Court of Canada that say that Canadian property owners accept the benefits of land use regulation, and they also accept the downfall. So if the lead smelter is put next door to me, or the garbage dump is put next door to me on my property value will go down, and I am not compensated for that. So there's a lot of regulatory space that governments can take up in the way in which we use our entitlements. And I argue that we haven't even begun to plumb the ability to take up that regulatory space for the exercise of water entitlements, such that we could we don't require compensation, we simply put, from a legislated or a regulatory perspective, additional conditions on the way in which you can use your entitlement. So in years in which certain hydrological conditions are occurring, we might say that you can only use your entitlement in certain ways. So it's an added aspect to the licensing part of the entitlement. And there could be a rich conversation about this, and there are lots of different ways to take up that regulatory space where we don't need to have a showstopper about whether compensation is going to occur or not for vested water rights. In a watershed, we have a governance failure if we're talking about drought, right? Just because urban users can afford to pay a lot to have green lawns doesn't mean that we have success from a watershed perspective. So there's lots of room for demand management as well. But as long as we have senior rights holders relying on those from a legal perspective, given that they are based on a misunderstanding of how much water is in surface water sources, and I'm not even dealing with the whole groundwater issue, given that they're based on an unscientific and a misunderstanding of how much water we have, and also they are not reflective of climate change or changing priorities in water use at all. Really, we will ultimately end up where the folks in the Klamath Basin, which straddles Oregon and California, ended up about 3 or 4 years ago. At the headwaters of the Klamath, we had a variety of ranching families, thousands of ranching families. We had Indian tribes who were interested in bringing the fish back because there are several dams in the Upper Klamath. And then we had the fishermen, the commercial fishermen, interests in reestablishing spawning grounds in the Upper Klamath, given the impact of not having those spawning grounds on the ability to reproduce fish. And after about 20 years of litigation, millions and millions of dollars spent trying to reinforce or enforce senior water entitlements, They all came to the table and said, okay, we have no water. There is no water for fish, there's no water for watering our potatoes. We're going to lose our agricultural contracts. What is it that we can do ultimately to satisfy our interests to an extent, claw back our water use, and get some kind of community of watershed users to be able to actually function as neighbors and as a community. And I'm not going to go into the details, it's really, a lot of it is online, but if you look at the Klamath Basin agreements, there's a hydroelectric agreement where they're going to dismantle 2 dams, and then there is a very detailed agreement amongst the tribes, who are actually the most senior license holders, all of the ranchers, and then the fishermen associations. So it's a very interesting example when law fails, when we simply don't have enough of a resource anymore. And in the case of water, it's going to become very clear over time that law will fail. So are we able at a watershed scale then to devolve to watershed governance and collaborative shared decision-making or solutions before we have to get to either a place where we have farms failing because there isn't enough water, or we simply have fish extinction because there isn't enough water?